come Monday, the injunction put on the state of Illinois to enjoin them from enforcing the gun ban could kick in after the 30-day stay from District Judge Stephen McGlynn will be lifted. He issued a permanent injunction back last month, but in ordering that injunction, he put a stay on his order for 30 days. Right now, it's in the appeals court, and there's some interesting back and forth. I'm Greg Bishop. Thanks for being with us each and every weekday morning as part of America's Talking Network for Illinois in Focus. We've been tracking the gun ban litigation, and the latest we'll pull up here. This is from the court docket in the appeals court, because as you've got this case that's progressed, the state banned semi-automatic firearms like rifles, shotguns, and handguns, magazines over certain capacities. That happened in January 2023. It was a bill that was gutted and replaced during lame duck session, and in just a handful of days, it was passed by the General Assembly and into the governor's hands, and he signed it, so it went into effect. About a week later, lawsuits started filing in. State lawsuits, federal lawsuits, plaintiffs saying that their Second Amendment rights were being infringed. A lot of different arguments made, but the cases that really stuck around were the cases consolidated in the Southern District of Illinois Federal Court. Now, if you recall, preliminary grounds, the district court granted an injunction in April 2023. It only lasted 6 days before the states got a stay on that injunction while the appeal played through, and then ultimately the appeals court overturned the injunction on preliminary grounds. All right, so after the appeals court took that action, plaintiffs then decided to try to take the case to the U.S. Supreme Court on preliminary grounds. And earlier this year, Justice Clarence Thomas denied taking up the case on preliminary grounds out of Illinois because it wasn't done yet. He wants final judgment on these cases. They're anticipating getting a case on final judgment. Could it be the Maryland case that's currently in for being talked about during a conference on December 13th with the U.S. Supreme Court? So we'll be watching that. But the Illinois case, after the Supreme Court earlier this year said, no, we're not taking this, it's not ripe yet, it went back to the district court where Judge Stephen McGlynn held that 4-day bench trial and heard all of the experts that the state and the plaintiffs brought forward, talking about the difference between military-grade firearms and firearms that are available to civilians. After that 4-day bench trial, a few weeks later, you had the judge issue a permanent injunction on final order. This is in the district court. He issues the injunction, but he grants a stay. State then files for an appeal in the 7th Circuit U.S. Court of Appeals. And the appeals court then said, hey, the judge's ruling's deficient. You guys need to respond why we shouldn't narrowly put this back to the district court for a more clear order. We also had the appeals courts go ahead and give a deadline for both sides to give their arguments as to whether or not a stay should be granted as the appeal plays out in the 7th Circuit U.S. Court of Appeals. So those were the two different things that the plaintiffs and the state were being asked to respond to in the appeals court, with that Monday, December 9th deadline coming up for when McGlynn's stay on his injunction will lift and the injunction would kick in. So the timing here is interesting. So we previously and yesterday we reviewed all these different documents that were filed by the state and by the plaintiffs. Right, and the most recent were about the issue of whether or not a stay should be granted. The state filed that back on the 15th of November. The plaintiffs responded by Monday, and then late yesterday, the state ended up replying to the plaintiffs. So we have that now in front of us. So let's go ahead and tackle this here. Reply in support of motion to stay injunction pending appeal. So this is from the states. For the second time in 2 years, the district court enjoined defendants from enforcing the Protect Illinois Communities Act in its entirety and statewide. Defendants have explained why the court's opinion, which conflicts with opinions of the 1st, 4th, and D.C. circuits, as well as this court's own opinion in Beavis v. Naperville. That's the case that Robert Beavis with Law Weapons has against the city of Naperville that was filed before Illinois even enacted a statewide ban. But the defense yesterday, the state of Illinois, in their filing, said it's likely to be reversed and why its injunction, if it takes effect, will damage public safety in Illinois. Plaintiff's response identifies no persuasive reason to allow the injunction to take effect. The court should stay the injunction and preserve the status quo while it considers the appeal. They make their argument. The stay motion complies with Rule 8, and they talk about Rule 8. Let's go to another headline here. Defendants are likely to succeed on the merits. They say that in their filing from yesterday, late, the defendants explained why they are likely to succeed on appeal. Plaintiffs failed to show that the weapons regulated by the Act are arms protected by the Second Amendment, and defendants established a historical tradition of regulating dangerous and unusual weapons. Plaintiffs' responses are unavailing, they say. Also, another headline here, assault weapons and large capacity magazines are not arms. They argue that first, as defendants explained, the district court erred in concluding that assault weapons and LCMs are arms covered by the Second Amendment. The record showed that assault weapons and LCMs are more like military-grade weaponry than firearms suitably used for self-defense, the state argued. And the district courts reached a contrary conclusion only by rejecting the framework that Bevis set out and accepting arguments that Bevis rejected. Plaintiffs' attempts to rehabilitate the district court's Step 1 holding lack merit. They go on to talk about plaintiffs' primary defense of the opinion below. In this court, Bevis specifically contemplated that the parties might amass a factual record that would demonstrate that this court's preliminary views are mistaken and that what occurred below. And that's what was plaintiffs, they say, are half right. The parties did compile an extensive record regarding, among other things, the weapons regulated by the Act and their similarities to military-grade technology, but the district court's Step 1 reasoning did not turn on its engagement with that record. Rather, the court's reasoning turned largely on two facts, both of which were considered and rejected by Bevis. The assault weapons and LCMs are commercially popular, and that assault weapons like the AR-15 are unlike their military counterparts because they are capable only of semi-automatic fire. The district court, in other words, did not sift through a mountain of evidence to reach its one-step conclusion, as plaintiffs suggest. Rather, the court issued an opinion that largely tracked its prior views and the reasoning of the Bevis dissent. So it continues on there. It's about 13 pages of arguments where they lay out why they think the stay should be granted and the injunction should not take place. They say that the Act is consistent with history and tradition. They give their rationale for that. You also have another headline here: the equitable factors necessitate a stay. Finally, a stay should be granted because of the equitable factors favoring restraining the status quo pending appeal. Plaintiffs' handful of counter-arguments do not show otherwise, the state argues. Plaintiffs' primary critique is that defendants merely speculate that allowing the injunction to take effect could damage public safety in Illinois, but there is a documented link between mass shootings and access to assault weapons, the state argues. And as the D.C. Circuit observed during the week in which California's analogous LCM ban was enjoined, over 1 million LCMs flooded into the state. So this is hardly a case in which the claimed harm to the public interest is based entirely on speculation. The harm to the public interests rests on the well-supported connection between assault weapons and violent crime. Defendants pointed to the evidence in the stay motion, but plaintiffs did not address it, electing instead to simply assert that defendants' arguments rest on conjecture, but saying it does not make it so. They go on to conclude. Final paragraph here: plaintiffs also do not seriously dispute the injunction's limited scope underscores the need for a stay. Plaintiffs do not dispute, for instance, that the district court enjoined the statewide enforcement of provisions that plaintiffs did not challenge and that the court agreed were constitutional. Plaintiffs simply say that if there's an issue with the clarity of the district court's injunction, the court can address that on remand. But the issue is not that the injunction is unclear. Rather, the district court clearly stated that it was enjoining the entire act based on its view that its provisions were not severable, meaning you can't, separate pieces out of it. Plaintiffs appear to agree that the description of the injunction, so the issue is not the injunction's clarity, but its breadth. Plaintiffs assert that the injunction is not unbounded because it applies only to citizens in Illinois who wish to exercise their Second Amendment rights, but that is circular, they argue. The state says the court's injunction is flawed and overbroad. it should be stayed pending appeal. The court should stay the injunction pending appeal. So that's the conclusion here. So that's the latest filing. Again, the state filing that late yesterday in response to the plaintiffs saying that there shouldn't be a stay on the injunction, and the injunction should be allowed to kick in, preventing the state from ultimately enforcing the gun and magazine ban. So again, it's in the state's, the appeals court's hands here, the 7th Circuit U.S. Court of Appeals. And what happens, we'll obviously be watching that docket for any orders that come out, anticipating a couple of different orders. One dealing with the issue of the stay, whether a new stay will be put into place. The other one dealing with whether or not to narrowly remand the case back to the district court for a clearer order, according to the appeals court. Keep it here. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. We'll update you each and every time there's an update to be had. Get headlines at thecentersquare.com and get the podcast where you get podcasts. Just search Illinois in Focus.